Hello everyone, I'm Jim Ganther, CEO of Mosaic Compliance Services, and here's my colleague.
I'm Scott Clay, General Counsel for Mosaic.
Scott and I are both very interested in the Carrs Rule litigation currently pending before the Fifth Circuit Court of Appeals. That case, NADA and TADA versus the Federal Trade Commission, heard oral arguments last week in New Orleans. We both intended to be there. Unfortunately, Hurricane Milton had other plans, and we were forced to stay in Florida, weather the storm, and listen to the proceedings, which the court provides live streamed audio. So we're able to hear the arguments, but not see them. How effective was that for you in your understanding?
Well, it was difficult because you can't quite ascertain which judge is speaking at a given time, and I would have loved to have seen some of the reactions on the faces of the attorneys during their questioning by the court. It was a pretty hot bench. The three judges on the Court of Appeals panel handling this appeal had a lot of questions, and I thought the court did a good job in probing each side, and I thought the lawyers for each side were well prepared.
I would agree. Now, NADA and TADA, the petitioners, were represented by Jeff Harris, and he spoke first, and he spoke for 25 minutes, reserving 5 minutes for rebuttal. But he didn't get very deep into his arguments before he started getting hit with questions. I would say he was trying to stress three main points. First, that the Carrs Rule should be set aside because the FTC didn't follow its own mandatory procedure in enacting it. Specifically, the FTC did not issue an advance notice of proposed rulemaking.
Yes.
His second point was that the FTC's failure to issue an advance notice was not harmless error. And third, that the FTC's entire process was arbitrary and capricious. The argument focused, I would say, on the FTC's suspect cost-benefit analysis and confusing, ill-defined terms in the rule, such as offering price and express informed consent. But he didn't get very far with any of them before the court got on him.
And I would say that the briefs also had a third category, which is, was any kind of rule required at all? The NADA made this point that auto dealers are already heavily regulated, and there's not really a need for a rule like this when there's already existing law governing the same kind of conduct. And I thought it was interesting that that argument didn't really get addressed by the judges. They didn't really want to hear about that during oral argument. They just wanted to hear about the advance notice question, and they wanted to hear about the cost-benefit analysis conducted by the FTC. And those were the two issues that really tied up each side in dealing with the judges' questions.
I think it's fair to say that the questions that we heard that were put to Jeff Harris were also put with equal vigor to the FTC's lawyer, Ben Akin. And you know, they both had to address those issues, and yet both kind of wanted to get back to their train of thought.
Right.
It's fair to say that the judges weren't being hostile. I would say they were being very thorough.
Yes, they were courteous and they were professional.
Yes, they were.
And each lawyer did a pretty good job. They didn't have all the answers, which is understandable. But I thought the bench did a good job in probing each side. But it did see, I don't know what you think about this, but it seemed to me that each side had at least one judge who tended to favor them, was my feeling from listening to the questions.
Yeah, not being able to identify which voice was which judge was a bit of a problem, but I think we agree it was Judge Stephen Higginson who seemed to favor the Federal Trade Commission, and it seemed to be Judge Smith favoring NADA, TADA. Was that your take? Yeah,
that was my conclusion as well. And I could recognize Judge Smith's voice, I think, because he had a distinctive Southern accent, and NADA counsel referred to him by name a few times after he had made comments. But Judge Smith kind of tossed up some big softballs for NADA counsel to hit. He gave him some hypothetical fact patterns that would support his position, and he seemed to only criticize the Federal Trade Commission.
And that leaves the third judge as the potential tiebreaker, and that was senior judge Higginbotham. Now, what do we say? A good lawyer knows the law, a great lawyer knows the judge. And we really are straining to, read the tea leaves. And it really means reading the judges. How do we think the judges are going to rule? And we got a clue. I thought we got a clue. If you just listened to the questions and the repartee between the court and the attorneys, you could say it came across as being something like a tie game. But there were two things that happened that tilt me towards believing that the FTC is not going to prevail. And those two things were one of the judges bringing up the case Wages and White Lions Investments, LLC, versus the FDA. And that was a case that was heard at the Fifth Circuit level, and it went to an entire en banc hearing. En banc meaning all of the judges, approximately 15, heard it at the same time. And that's pretty rare, isn't it? Do you get an en banc hearing?
Yeah, that you have to file a motion to request that. Of course, the judges themselves can also seek a polling on whether to have an en banc review. But I think it's only 1% of the cases that go down that path, because the caseload is so heavy in the courts of appeals. Usually each individual case is determined by a panel of just 3 of the judges.
Right. As in our immediate case, but in that en banc hearing, it was, I believe, about 15 judges. But here's the key part. Judge Higginbotham wasn't on the panel, but Judge Smith and Judge Higginson were.
Yes.
And in the case of Wages and White Lions, it involved a vape manufacturer trying to get approval from the Food and Drug Administration to be able to advertise new products, and they followed all of the procedures, and then the Food and Drug Administration said, nah, you can't do it after all, and essentially changing their procedures. Arbitrary and capricious behavior under the Administrative Procedures Act, which is the legal theory that's being tested in this case. So the court split about 10-5, and in the dissent, in the minority, was Judge Higginson saying the FDA did no wrong.
Well, neither of the judges actually wrote the primary opinion, nor the dissent in that case. They just joined in the vote.
Their votes went that way. And Smith said, no. Smith voted with the majority that said, no, the FDA acted in an arbitrary and capricious manner. Right. Higginbotham wasn't on the panel at all.
Right.
Because he's a senior judge.
And we're not sure who mentioned this case during the NADA FTC oral argument. It might have been Higginbotham. I tend to think that was probably Judge Higginson who mentioned it.
But it wouldn't. The thing is, Judge Higginson joined in the dissent. He was on the losing side. Right. And by the way, that case is now docketed before the Supreme Court.
Right, because there are actually 2 other opinions on that exact controversy in other federal circuits. And there's a split. There's a disagreement among the circuits as to how that case should be treated with the FDA.
Judge Higginbotham, being senior, only has to maintain at least a 25% workload, and he still keeps his staff and his clerks and his office. So the fact that he wasn't on the panel, he didn't have to be, because he is a senior judge. So he is the wild card. But Smith was appointed by Reagan, and so was Higginbotham. They are Reagan appointees, whereas Higginson was an Obama appointee. I'm thinking that this is going to a 2-to-1 in favor of TADA, NADA, but what would that ruling do? What might that ruling do?
Yeah, I'm inclined to agree that it's going to be a 2-to-1 vote in all likelihood. And one of the judges, again, we don't know if it was Higginbotham or Higginson, asked at the end of oral argument during NADA counsel's rebuttal period.
Right, it was like after the 27-minute mark.
Yeah, one of the judges asked counsel, say, didn't you bring up in your reply brief this notion that we could simply remand this case back to the Federal Trade Commission to fill in gaps in the record and retain jurisdiction to review whatever they come up with after that activity takes place?
Exactly, and I've got the briefs right here on my lap, and on page 25 of NADA TADA's final reply brief, alternatively, this court should remand the rule to the FTC. This was a question that didn't need to be asked. It was right there in black and white in the brief. So I took that as a signal that rather than throw the rule out in its entirety or throw out the petition in its entirety, they could give it back to the FTC and say, please consider all of these things that were brought up in the original petition, then bring it back to the court, and then we'll rule. That creates an incentive, essentially, I'm going to call it for settlement, for a negotiated, let's decide what the FTC really needs and see if we can come to some kind of an agreement where both sides will come back to the Fifth Circuit and say, we can live with this.
I think that's very likely, Jim. And if that is what the court does, where do you think things might shake out between the NADA and the TADA and the Federal Trade Commission working out some kind of possible compromise tweak to the rule?
Well, let's think about it from the Federal Trade Commission's perspective. Why did they issue this rule in the first place? What were they going after?
Right.
They will deny it. They have denied it. But I believe they're trying to rectify the result of the AMG capital management case, where the Supreme Court 3 years ago in a 9-0 decision said the Federal Trade Commission lacks the statutory authority to assess monetary fines in the first instance.
Well, I don't think they'll deny that at all, because their lawyer even said that and acknowledged that during oral argument. So I think that is their primary motivation here.
And you know what? Everybody has assumed that these bad acts have been illegal. They have been illegal. And the Federal Trade Commission has been assessing monetary fines against them for decades. So getting the formal authority to do what they've been doing forever, that's not a hill we want to die on. They can have that.
Yeah, and I think that also is apparent from the fact that, as we discussed a little earlier here, none of the judges had questions about these arguments that we don't need more trade regulation. That this didn't seem to appeal to them at all. Yeah,
I mean, I saw Jeff Harris trying to make some hay with that. But this seems to be formalizing what has been at least common law for decades.
Yeah.
So I think they're going to be able to get the ability to define these bad acts as deceptive trade practices, get the ability to assess monetary fines in the first instance against violators. They may, no, I would be pretty certain that their requirement for training will survive, because we've seen that over recent major rules. The safeguards rule requires training.
Yes.
The red flags rule requires training. So that's not that big a lift.
Yeah, and that was an element of cost benefits that the judges didn't even question as well.
Right, and there will be costs. Remember, we are in the compliance business. We sell this training, we develop this training, so we know what it costs. And by the way, it is not zero, or we would not be in business. And the FTC saying that the cost is zero is just indefensible, and part of why we filed an amicus brief. That assertion was nuts.
And when the judge raised the question during oral argument about remanding the case to fill in the gaps, NADA counsel didn't refer specifically to this, but it is in their brief, and that's his proposition that, say, the FTC could receive more evidence from the compliance industry about those costs, because those costs were completely overlooked and ignored in the promulgation of the rule.
They were just dismissed out of hand without, serious consideration. What do you think NADA TADA needs to get from an ultimate CARS rule to go away peacefully?
Well, I haven't had any conversations with their counsel about that. I think the most burdensome element of all of this, and it also involves the most ambiguity, well, two things. The express informed consent issue, it's just completely unclear from the rule as written how that's supposed to be accomplished and demonstrated. And this requirement of a constant redrafting and providing to the consumer cost estimates for whatever products they may add on to the purchase as they're going along, and that changes. Now we have to have a new monthly cost assessment. And one of the things that NAD Council mentioned during the oral argument was, gosh, with the TILA requirements, you just have to provide that one time before the consumer signs. So if that's something that the FTC compromises on, I could see NADA agreeing to that.
Mm-hmm. Yeah, I would say that the offering price and its disclosures are ridiculous, that you're currently, under the terms of the rule, required to say what is the offering price, what we might call the cash price of the vehicle, in the first communication with a consumer about a specific vehicle. Even if the consumer says, is that vehicle in stock? Let me tell you how much it's going to cost. Do you have that in blue? It's $48,512. Can I get a lease? Backward reels the mind. That has to go. The disclosure requirements are unwieldy. It's going to make the process less consumer friendly, lengthier, and I believe more confusing. So I think there is middle ground where the parties can come together and say, this far is enough. FTC, you got 80% of what you wanted.
Yeah, I think on the offering price, maybe if that's limited to advertising, perhaps? Do you think that flies for the NADA?
Advertising, the cash price with all costs into that advertised price.
I think some states require that already.
It makes perfect sense. But the specific objection I keep hearing is you keep running into this dealer fee. Call it dealer fee, doc fee, pre-delivery fee, whatever. That I was looking at a new car today, and it was very prominently displayed on this dealership's website that does not include a $20 tag fee, because they use an independent private tag company to do the title work, and call it a document fee of $1,200, $1,199. It's very prominent. It's separate from the advertised fee, but it's very prominent. You cannot miss it. It's advertised next to every single vehicle. But fundamentally, everyone who buys a car in the United States has come across that fee. I'm acting as an expert witness in a particular case where that's one of the main issues. You didn't advertise your doc fee. So I did a survey of every Honda dealer in that entire region, and two things stood out. Every single one of them had a doc fee, and every single one of them used the exact same Honda website template. So everybody in the industry knows that this is common usage, and everyone in the market, except perhaps for the 18-year-old buying his first car, might be shocked to see a doc fee. But everyone else, including everyone at the Federal Trade Commission, knows there's going to be a doc fee, and furthermore knows you can negotiate against it because it's a price negotiation. So I see both sides of the argument, but I honestly don't see the monumental damage of people being shocked by a doc fee at the end that they don't think is subject to negotiation like every other term of a car deal.
Right. Well, it'll be interesting to see what happens if the case does get remanded.
Let me ask you this, Scott, because you get asked this question all the time. When are we going to know? When will they give an opinion?
That is the most common question I hear when I talk about this case, and there is no specific timeline requirement for the court to rule. I've seen some data collection for the Fifth Circuit that I believe suggests from soup to nuts filing of the case to the ruling on average is 9 months. I think we may already be right at that point. But if they're going to remand it for the Federal Trade Commission to fill in gaps, I think that ruling will come pretty quickly.
Right. It doesn't take much time to say remand.
Yeah.
Whereas a reasoned opinion on all the very, very nuanced legal issues. Was this an 18A1B rulemaking?
Right.
Or 18A1C?
I think the legal elements of the case do involve some close questions, and neither side had case law exactly on point as to whether that advance notice had to be given. Neither side had case law exactly on point as to what kind of review the court could conduct with respect to the cost-benefit analysis. So in my experience, when judges can avoid making rulings that would be new law, if they can avoid that, they tend to do so. So I think that further buttresses our conclusion that this could be a remand to let the parties try to work something out, or at least to make the FTC consider additional evidence and argument.
I don't know what else we can say about it. We love geeking out on stuff like this, and I know we're both sympathetic because we've both done oral arguments before and oral appellate arguments, and they're high pressure. So hats off to both counsel.
Yes, I thought both gentlemen did a fine job, and reading the tea leaves is fun, but we really don't know what's going to happen. I've sat there before arguing before a court of appeals, and my light indicating my time is over is flashing, and they are just hammering me with further questions, some snarky even. Walking out of the courtroom, opposing counsel said, "You can have your client send their check to my office now if you want." And then a month later, the court rules in my favor.
Yeah.
So you don't know for sure, but
So we're reading tea leaves, but the Fifth Circuit might be brewing coffee. And with that, thank you very much for watching. I'm Jim Ganther.
I'm Scott Clay. Thank you.
And when we know, you'll know.